Good morning, Your Honor.
All right, good morning to all. Took a bit to get my little remote thing going here, but I think that we're all good to go. So pardon the delay, but we're going to move forward. Just one moment here. Is everybody able to, somebody say something, make sure you're hearing me. Good morning.
Good morning. We can.
Good morning, Your Honor.
All right. Perfect. All right. The first up matter, if you will, in the order that was given to me, we'll try to move through things rapidly. If somebody's not here, we'll move on to the next matter in the interest of expedition. Just one moment here. All right, the court first calls case number 15-117948. This is Auto and Work Comp Rehab LLC versus Ebony Ivory. The matter is before the court on the filing of a motion. That motion sounds in a motion for relief from judgment. The record should reflect in this matter that judgment was entered by default on the 23rd of, looks like I should say the 4th of December of 2015. The judgment upon entry was $18,174.30. I've had an opportunity to read the motion as well as the response to the motion in this matter. Your appearance for the plaintiff in this matter.
Good morning, Judge. J. Latif Baig, B-A-I-G, P36820. Appearing on behalf of plaintiff and the attorney of record. Judge, I'm covering for attorney Robert Warner today. Thank you.
All right, thank you, Mr. Bagan. Good morning to you, sir. For Miss Ebony Ivory, if you will, at this time, your appearance, please.
Eric Stone to be appearing on behalf of Miss Ivory.
All right, thank you. Your P number, if you will, for the record at this time, sir. 55304. All right, thank you, Mr. Stone, and good morning again to you. I had an opportunity to look at the brief and, of course, the motion. And, of course, you guys have put enough mud in it. That doesn't mean anything derogatory, but you muddy the waters a little bit. This looks like a case that dates back to maybe 2012 or 2013, a first-party benefits case as well as a third-party suit that seemed to have been commenced in circuit court, and something was resolved. It seems that there was a arbitration or mediation or something, and a resolution thereupon, and thereafter the proffer of a check to the defendant in this matter was rejected, it seems, and the plaintiff proceeded with its rights at law, as they would assert. That's about the size of this, counsel.
Yes, with a little more, they decided to pursue after the statute of limitations is gone.
Yeah, you didn't raise the statute of limitations issues within the context of your motion. You certainly raised the issue that you were not notified of the lawsuit, and you were representing the defendant in the other matter. So give me your hardcore basis as to why you believe that this judgment, that you should receive relief from the judgment that was entered in 2015.
For one, we weren't notified, and if we had been, we would have came to the hearing and argued statute of limitations, argued that this was this case was arbitrated, argued they had their right to bring in their own cause of action based upon an assignment. There are many additional things that could have resulted from a default in this case had we known about it. Number one, the defense of statute of limitations for sure. And number two, that this was a binding arbitration in the circuit court, and that arbitration awarded them a certain amount based upon the facts and circumstances of the case.
All right, and do you concede that with regard to the arbitration, that under the current state of case law, that the defendant, without a stipulation to the same in that matter, I should say the plaintiff here, is not bound to accept that arbitration award in any way that would be dispositive to this case? Do you understand that, or do you disagree with that?
I do disagree with that, because this is a no fault case. This isn't a regular case, your typical case. We have a no fault act that allows recovery through that act, and they didn't follow that act. That's the problem here. We litigated the case. They could have been part of it or on their own.
All right, but you say nothing in the, you certainly, because there's nothing there, you say nothing in the no fault act that would would militate against the notion that there is case law that is on point in this regard, that unless the plaintiff in that setting is in agreement with or a party to the mediation arbitration, that they're not bound by the same.
Your Honor, I don't have case law either way on that. I was not prepared, but I have never had in my 30 years a provider not accept what the arbitration was. This is my first time in 30 years that they say no.
Yeah, and I mean, obviously that's a part of the rub. Here, let me ask you another question. I'll go to Mr. Bage in just a moment. And that other inquiry has to do with, this is a matter where a judgment was entered in 2015. We are 6 years out, and there is some information that suggests that the defendant in this matter and or your office knew about this somewhere along that line. And the motion in this matter is filed somewhat recently in November of 2021. So about 6 years later. Why should there be any relief when that amount of time lapsed between the bringing of this action, the entry of the judgment in this matter, sir?
Is that for me, Your Honor?
Oh yeah, that's for you, Mr. Stone. I'm sorry.
Bill, they didn't. The case went away until they filed their default. The case was closed.
Yeah, but that default was filed in 2015. That's
no, Your Honor. That default I thought was filed just recently.
No, it looks like my register of action is showing me that default judgment was entered in 2018. Well, let me go to the other side and ask about that, Mr. Baker.
Well, then how come they didn't collect for 3 years later? I guess we never even knew about the default. That's the whole thing. And we only knew about the garnishment starting in 2021.
All right, thank you, Mr. Stone. Mr. Baker.
Okay, let me just pull the default here just for a second to answer your question, Judge.
Well, I have the court's register of action. The court's register of action show the entry of default on 12/4/2015. It shows a state income tax withholding garnishment in 2016, and then subsequent garnishments for several years thereafter.
Yeah, so the default was entered in 2015, and you want to note also the address for Miss Ivory on the default is the same address as it is today. And I'm assuming.
Let me stop you for a moment in the interest of time. All of those issues are not issues that are significantly contested here. What is contested here is the propriety of the judgment remaining in place on the notion and the premise that there was a arbitration and that arbitration process granted a reward to the plaintiff here, that is to auto and workers' comp rehab, and that should prescribe, or that should prevent or should have prevented the entry of the default judgment in this matter. And secondly, that your office, Mr. Beige, knew that Mr. Stone's office was representing Miss Ivory in the underlying case that was resolved at the circuit court level or through arbitration. Talk to me about that, sir.
Okay, with regard to whether the arbitration binds plaintiff. I think the case law is clear. Under that, the Miller decision, which is noted in the brief, and you probably have a copy of it, the plaintiff never acquiesced to the claim, to the settlement in arbitration. In fact, refused the $2,700 and whatever change check that counsel sent over to plaintiff. So I think the case law is pretty clear, and then also the lien agreement in the last paragraph clearly states that the plaintiff is not giving up any of its rights to collect fully on the debt. So I think that's pretty clear. Now, with respect to counsel's reliance on MCR 2.612 C, that's like a catch-all, and we cited the Elkin and Ziegler case, which states that.
Well, let me stop you in the middle of one of your odds. I don't think that the proposition that you raised, that the rubric that is required by the court rules as it relates to an affidavit of meritorious defense, et cetera, is a necessary component to the filing of a motion for relief from judgment, particularly under the circumstances set forth here. I don't think that that's the critical issue here. For sure, there is not a basis for attacking the filing of the separate action in terms of whether or not someone was served or whether or not someone received a document. Long since this judgment has been entered, over and over again, the defendant in this matter has been notified regarding this case and regarding the entry of the default judgment, and collection has been had upon that judgment over a number of several years. So those are not the issues that we're talking about. I think, and what we do get to is obviously when counsel raises a motion for relief from judgment, whether you want to call it catch-all or whether you want to call it the safety net, whatever you want to call it, the reality of it is that the court rules allow the court to take a look at the entry of a judgment to see whether or not there's a manifest type injustice that arises from inadvertence or from fraud or something along those lines. And that's what I'm looking for here, to see whether or not there is some inadvertence, some fraud or something along those lines, because that's really what this case drills down to. It drills down to whether or not there was something fraudulent that occurred here, or that there was some inadvertence. And then a third component of that the court has to consider herein is the amount of delay associated with bringing a motion for relief from judgment. And I'll drill down on that third issue in the first instance. And that third issue is that this judgment has been entered since 2015, and collection has been had on this judgment since 2015. And now we're in 2021 seeking to set it aside. I have not seen or heard, even out upon reading the motion, I've not seen any basis that would support allowing this matter to be delayed for that period of time. In other words, if this was a situation where no one knew about it and all of a sudden this pops up, then that prong of the analysis that the court has to work with would be a prong that the court would have to give a great deal of attention to. But that's not the case here. In fact, in one of the letters from the plaintiff here to the firm that handled this matter in circuit court, indicates that they are following after the entire balance and that they have brought a lawsuit. And so there is some notification even to the attorney in the other matter, even to Mr. Stone's office, and no action is taken over 6 or 7 years. So where is the fraud in this, or where is the inadvertence in this? And if you can point me to any of that, I will be glad to take a look at it. It's certainly not raised in the motion, except the suggestion that the unwillingness to accept the arbitration award somehow means that the plaintiff is the plaintiff engaged in some type of fraudulent activity. That doesn't make any sense. That doesn't make any sense. Certainly, if the plaintiff accepted the arbitration award, cashed a check without any type of recourse, then that would certainly be fraudulent to bring a claim after you've settled the case, and that's not what happened here. Nothing.
Your Honor,
go ahead, Mr. Stone. I'm listening to you now.
I think your timeline is a little off. They got the default on December 4th, 2015, but they never garnished anything until just recently. There were no income tax garnished. There was no garnishee until September of 21.
Well, I beg to differ with you, because our file shows that there were attempts to garnish at the state tax level on multiple occasions. Whether they received any money or not, that's another issue. It does show that in 2019 there was a disclosure, and looks like there was a release of some $1,500 towards this debt back in 2019. So there have been notifications in an effort to collect on this judgment over a significant period of time. That's the point that I'm making.
I don't have any of that information in front of me, because the only thing I have, and I'd like to find out how they can take money without a garnishment, because the garnishment was entered on 9/22/21.
Well, the one that you're talking about is the most recent one. There were other garnishments sent to the Michigan State Income Tax Division.
Well, when did those occur? When were those signed?
Well, I have a whole.
I don't have any of those.
You know, I'm not going to entertain you with all of that information right now, because that would take up all the time the court has this morning. But you can certainly get a copy of the register of action that emanates from the court, and it has numerous indications of collection efforts. And one of them seemed to have been successful in 2019, that related to a dispersal of some $1,504. That was in 2019. Subsequent to that time is the one that you're talking about, that I believe resulted in a garnishment of a significant amount. I saw something in a brief or something that suggested somewhere in the nature of $8,000 or whatever it was.
I do not have any response other than the one garnishee from them.
Very well.
Your Honor,
let me stop you, everybody. Mr. Stone, you told me this 3 times now. Okay, so you know, we're always kind and collegial here. You told me that 3 times. I believe you. Now, what I need you to do is to believe me that there is a court register of action that shows that there were multiple garnishments filed against the Michigan State Income Tax entity, and fair enough that you don't have that. But believe me, I have documentation that was done, and that there was a dispersal in 2019 in excess of $1,500.
Yeah, but right? Don't you have to sign an order for garnishment, Your Honor?
Well, no, I don't have to sign an order for garnishment. When there is a judgment in place, the plaintiff can execute on that judgment by issuing a garnishment.
Your Honor, may I just make one note? Exhibit 3 of our brief. There was a garnishment order where Miss Ivory filed an objection to a garnishment. So she actually filed an objection to a garnishment on March 2nd of 2017 to a garnishment that was issued on tax garnishment September 8th of 2016. So she inserted herself in the case. So really, there's been many opportunities here.
Let me stop you. I mean, it's okay that she filed something, and she obviously did not have the assistance of counsel involved in that, but she clearly found something, and there's clearly been a history in this case where there's a judgment that was entered many years ago, and there have been efforts to collect under that judgment over the horizon of about 6 years. That's the case. That's the case that's in front of me as it exists. Tangentially, what we're trying to figure out here today is how does this in any way relate to a previous case from 2014 or so, where there was undisputedly an arbitration decision that was made. The arbitrator determined that X amount of money would go to the plaintiff here. The plaintiff in its letters to the counsel for the then plaintiff in that underlying case indicated that they did not accept the award of arbitration, that they rejected it, that they were willing by stipulation to apply it towards the entire bill, but that they would go forward and bring suit on the entire bill. That's the gravamen of this case, and that case, a suit was brought. That case was not responded to, and a judgment was entered by default. All right, so
But that's,
Mr.
but we
Stone.
didn't have notice of that. That's the whole point.
Yeah, Miss Ebony had notice of that, but I understand your office did not receive the lawsuit.
Right, they're not lawyers.
You interrupt one more time, and I'm going to dismiss you from this hearing. If they're your lawyers, that means that you definitely don't have anything to say, and you definitely don't think that you could interrupt this hearing. Now, that's not being rude. You just can't do that, and I think that you know that. Common sense tells you that. Mr. Page, what do you have to say about that, sir? About the issue that Mr. Stone raises?
Your Honor, I think what you mentioned at length regarding the fact that they had opportunity. You know, Miss Ivory was notified of garnishments. She had received the default judgment.
Let me stop you as you're going on. No, here's what I want you to drill down on. They said that you should have sent the lawsuit to Mr. Stone's office. That's the issue now.
I would disagree. This is an entirely different case, and Mr. Stone's office was well aware that plaintiff was not accepting the arbitration, the $2,700 check. The check was rejected. They were on notice. The law firm's client, Miss Ivory, had opportunity to let counsel know.
All right, Mr. Stone, you get the last word on your motion.
Yeah, if we were.
Hold on, Mr. Stone. Mr.
Yeah.
Bays, you had hold on one second, Mr. Stone. You get the last word. Mr.
Okay.
Bays, you were saying something before you got cut off, sir.
No, I said what I needed to say, and I agree with your earlier analysis. There really isn't what you say a good cause in this instance. The judgment's been in place for many years, and there was numerous opportunities to object to this.
All right, thank you, Mr. Bays. You almost put me to sleep there, sir.
Yeah,
Go ahead, that's all right, sir. I'm just picking with you. Go ahead, Mr. Stone.
Your Honor, that's the whole point. There was a dispute and they don't let us know about it. And they sideswipe us and they go around the back door. And then 5 years later, we're left to clean up this mess. Had we known about it then, we could have taken care of the problem then. So, and they knew it was through us. They rejected, they sent us something. I mean, all they had to do was, they didn't even have to, they could have carbon copied us and we would have been okay with it. They didn't even let us know they were suing her. So it's a little disingenuous that we had notice of it. Yeah, we had noticed that there was a dispute, but we didn't have notice of a lawsuit. That's the whole point. The No Fault Act is to take care of the bills so everyone can, so it's done quickly under the facts and circumstances. Not any of this playing stuff. where we're not notified and we can't help Mrs. Ivory on this. That's the whole point, and that's why it's not fair, and it's not how do we call that? You said there was no good cause. Yeah, there's a good cause. The good cause is we should have been known about it. We should have been part of this case and representing her for 5 years now. That's the problem. And Your Honor, the award was $2,700. She's already paid 5 times that amount. This case should be done and over with.
All right, thank you, Mr. Stone. I've listened to the motion for relief from judgment brought under MCR 2.612 C1, and I've read and listened to the brief in response to the same. Obviously, there are some equities that exist within the context of this case that, if pressed upon to the point of excretion, they would suggest that somehow something happened here that shouldn't have happened the way that it happened. What our constraint is to look at what does the law have to say about this, and how does the law manage these type of situations. The number one issue that is raised here is that there was an underlying case that resulted in an arbitration, and that arbitration resulted in an award that affected persons that would participate in and concede to the award that was allowed. One of those parties to the litigation, one of those persons' entities was Auto and Work Comp Rehab LLC, the plaintiff in this case. When they received the notification of an arbitration award, they rejected it. They indicated that they were not conceding and stipulating to the same, and they returned the check. There's been nothing here that indicated that they kept the check. They did in their letter indicate that they would be willing to apply that towards any balance that there might be, but there was never a stipulation in that regard. They also indicated in one of their letters that they were bringing action against Ms. Ivory, and that they were suing for the entire amount of the balance. Herein is where the parties have a great divergence. The plaintiff strike that the movement here on behalf of Ms. Ivory, Mr. Stone, argues that the lawsuit should have been sent to his office, and they would have taken care of things from there. Well, the lawsuit was filed and it was served upon the proper party, and that is Ms. Ivory. Ms. Ivory had the duty and the responsibility to inform lawyers that were representing her, to the extent that Mr. Stone's office say that they were the attorneys for her, to notify them that she received a lawsuit, to notify them that she was being sued for medical bills or for costs associated with an automobile accident that she was in. To the extent that she notified Mr. Stone's office of the same, then of course, if they were representing her, it would be their duty to in fact respond to the complaint and to act upon the lawsuit that was being brought by Mr. Bege's office. I don't know whether she called Mr. Stone's office or not, or whether she turned the lawsuit over to Mr. Stone's office or not. But whether she did or not, the fact of the matter is that no one responded to the lawsuit. And no one responded to the lawsuit. Now, I know that the movement here wants to make that the responsibility of Mr. Bege's office, that no one responded, that if they had sent it to his office, to Mr. Stone's office, they would have responded. They filed a lawsuit and served it on the defendant in this matter. And again, I'm repeating myself now, the defendant had the duty and the responsibility to seek legal counsel and to utilize the counsel that she had in this matter at the time that she filed the lawsuit, and to timely respond to the complaint that was raised. She didn't have to use Mr. Stone's office, but she would have had to respond to the lawsuit. She did not respond to the lawsuit. She did not file an answer. She did not file a motion to set aside the default when it was entered. The default was entered in the normal course. After no answer to the complaint for 21 days or 28 days after that, a default is entered. After the default remains in place, the next thing that happens is a default judgment is entered. All of that happened in 2016, I believe it is. The court made reference to its diary. In 2015 is when all of that occurred. And over that period of time and up until now, the first time that there has been any motion to set this aside, any argument that this judgment should not have been entered, is in 2021, about 6 years after the judgment is entered. And that motion was brought alleging that there is fraud because Mr. Bage's office accepted the arbitration award, and now he wants to bring a lawsuit. Well, then I researched this, and nobody here is saying that Mr. Bage's office really accepted the arbitration award. They're saying there was an arbitration award. Everybody stipulates to that. Mr. Bage's office has provided a diary of information that shows that they unequivocally rejected the same, and that there is case law that allows them to do the same, that they are not bound by an arbitration award if they are not the participants in the same, and if they do not stipulate to the same. There has been nothing offered to rebut that. And so, no, don't raise your hand. I've already given you opportunity to speak. That's why I gave you the last opportunity to speak. And it's not anything out of rudeness. This is where this case is right now. Where this case is right now is that I don't see the safety net provisions that are allowed, or that the court should look at when evaluating the matter under MCR 2.612 C1 and the provisions connected there too. And that is the court is looking for is mistake, fraud, inadvertence, excusable neglect. I know that one of the things that was raised here is Mr. Stone began to attack the court, saying something about cause. What I was saying simply was that the plaintiff, in order to support, or I should say the movement, in order to bring their motion forward, did not have to establish the normal rubric under the motion to set aside default, where you have to show good cause and a meritorious defense. There's a different rubric that you're looking at when you're looking at MCR 6.12 C1. That's all the court was saying. Mr. Stone seemed to think that the court was saying that there is no cause. There is cause for bringing this motion. There's cause for why this case is where this case is. There is a whole lot of cause here, and there may be even some fault here. The reality of the matter is that there has been undue and unnecessary delay in responding to the complaint in this matter and responding to the entry of a judgment. I look at this with some degree of frustration, thinking that maybe the case could have been resolved somewhere along the line for something way less than what has occurred in this case. But I look at this and I know that the arbitration award was $2,700. A judgment enters for $18,174. Maybe that's what the bill is, but it seems to me that somewhere between $2,700 and $18,000 that reasonable attorneys would have been able to talk about this had Ms. Ivory turned over the document to her attorney. Maybe she did, but if she didn't, that explains what the problem is here. But had she done that, reasonable parties would have been able to reach something that is more accommodating than these numbers. And now everybody looks to the court, and I have no problem with that. Everybody looks to the court to work out what is reasonable and equitable under these circumstances, and to somehow jump through the hoops of what the law dictates under these circumstances in order to reach a conclusion. Well, here's where this case is. You bring a motion, and it's the only reasonable motion that you could bring for relief from judgment, but you don't provide anything that gives the court a basis for saying that there is inadvertence, that there is a mistake, that there is some type of fraud that's involved. There's nothing offered there. It's just not there. And I know why there's nothing offered there. There's nothing offered there because there's just not anything that's there. It's just not there. Now, certainly if you have some other motion that you think that you should bring to address some other issue in this regard, then you certainly would want to do that, I suppose. But 6 years later, and nothing showing fraud, inadvertence, mistake, anything along those lines. There's nothing showing that. And again, Ms. Ivory's responsibility, and I can only put it on her at this point, because I don't know whether she turned the document over in 2015 to her lawyers or not. But when she received that lawsuit in 2015, she was supposed to turn that over to her lawyers or bring it to their attention that she's received a lawsuit. And I'm sure they would either told her, we don't represent you in that, or they would have told her that we'll file an appearance and we'll get your answer in. But here we are 6 years later saying it's the plaintiff's fault in this case, that this case is in default, and that that there is a judgment that hangs over the head of the defendant in this matter. I don't see a basis, even looking at this with as keen an eye as I can, even looking at it, trying to figure out equities and so on and so forth. I don't see a way to jump over the hoops of what the law requires in such circumstances and jump over the hoops of the delays that have accompanied this. The filing of response to motions for filing a response to orders for garnishment, but never filing motions to set aside a default, never filing motions for relief from judgment. It's only when it seems that a significant amount of money is attacked that then the motion for relief from judgment is filed 6 years later. There's nothing here. The motion is denied for all the reasons that I've set forth on this record, and I say that somewhat. With a heart that is somewhat displeased with whatever happened here. But there's nothing here that did not follow the law and follow the rules. And because the plaintiff has followed the law and followed the rules in this matter, they receive the entry of a judgment by default, and that judgment stands at this point where the motion for relief from judgment is being denied at this time. All right. I wish you well. I'll issue an order consistent with the same. All right. Good day to the two of you.
Your Honor, may I make a record?
You already made a record, but if you have something else you want to say, go ahead, sir. Quickly.
It's my point that they didn't have the right to bring a default because an assignment was signed. Therefore, that gives up all Mrs. Ivory's rights, them to collect against Mrs. Ivory. The court was misled in 2016.
What was the court misled about, sir?
That there was a valid contract between Miss Ivory and the plaintiff. You weren't presented with the assignment at that point in time in 2016. The assignment says that when you sign an assignment, each party gives up rights. The right was that they don't have a right to collect against Miss Ivory. That was the whole point of an assignment. That was never brought up in 2016. Had we known, we would have brought that up. That's my record.
All right, thank you, sir. I don't think that has any application here, and it's certainly not something asserted in your motion, as was the issue that you raised relative to statute of limitations. That was not properly raised in the motion either. But I've allowed you to put that on this record since you desire to do that. All right, thank you. I made my ruling on the motion. Good day to you.
Thank you.
The court is calling now case number 16-115473. This is Bright Right Financial Services Incorporated versus Tramiel Rush. The matter is before the court, an application for a subpoena arising out of entry of a judgment in this matter. This is the plaintiff's attempt to collect upon the same. Counsel for Bright Right, your appearance at this time.
Timothy Frost, Your Honor.
All right, thank you. Good morning, Mr. Frost. Go ahead and put your P number on the record, if you will, sir.
Yes, it's P40616, Your Honor. Sorry about that.
All right, thank you, Mr. Frost. Do I have Tramiel Rush on this Zoom? Tramiel Rush, if you're here, please say something at this time. All right, it looks like, again, this was set on for 9:30 a.m. It looks like the defendant has not appeared, although the court directed a subpoena in this regard. Your pleasure at this time, counsel.
Yes, Your Honor. Mr. Rush was personally served with the subpoena in order to appear on December 28th at 2:59 p.m. at his home on Sturtevant. At this time, we would request issuance of a bench warrant.
All right, the court at this time will grant your petition for an order to show cause as to why the defendant should not be held in contempt of court and why a bench warrant should not issue. And I'll sign an order for show cause upon its presentment. And counsel, if you'll present the same, you can do that by way of email. You can email it and I'll get it all signed up and we'll get it back to you and set a date for the hearing on the show cause. If the defendant doesn't show at that time, the court at that time would issue a bench warrant.
All right, the court will issue a date when we send the paperwork in, or did we put the date?
No, go ahead and get that's why I'm going to give you the the email address so you can email it out, and then we'll
Go
get
ahead,
it
Your Honor.
we'll get it right back to you with a date. That's Latifah, Latifah at
Yes.
Latifah.hunter at 36 District Court. That's 36CH at 36districtcourt.org.
Got it.
All right.
And may we serve that by first class mail, Your Honor?
No, I require personal service on it. So get it to me right away so that I can get your I can get it back to you with a date on it, and then you get it personally served, and we'll bring it in and let's see what we can get done. All right.
Thank you, Your Honor.
All right. Thank you, counsel. Good day to you.
You too. Bye-bye.
Just one moment. All right, this is case number. Yeah, this is case number 2164776. This is For Transport Incorporated versus For Your Recovery Therapy LLC, Gravity Imaging LLC, and Michigan Auto Insurance Placement Facility. Today is the date and time set for pretrial regarding this matter. I previously heard a motion on this matter. Your appearance for the plaintiff at this time, if you will.
Eric Stone, P55304.
All right. Welcome back, Mr. Stone.
Welcome back.
Good. All right. For the defendant in this matter, please.
Good morning, Your Honor. Talitha Mahone, P79890.
All right, thank you, Ms. Mahone, and good morning to you. So, sir and ma'am, I think I already addressed at a previous time a motion for summary disposition in this matter, and then I set this matter over for a pretrial conference, and I note that I received a motion for show cause relative to the principal plaintiff not appearing for a deposition. And so in this pretrial, I want to take up that issue as well as any other issues that you may need the court's engagement on at this time. Mr. Stone, I see you're raising your hand. That's very interesting in my Zoom, but go ahead, sir.
Well, I don't want to interrupt, Your Honor. I just wanted to let you know that I have, first of all, the principal plaintiff, the person who's being deposed is not a plaintiff in this cause of action.
You know, the notion that I got from looking at the motion was not in this cause of action, but that this was the injured party, that this claim is being brought for recovery of services, and that Miss Shakira Lindsay Harvey did not show up for. I know she's not a plaintiff in this case. I refer to it as underlying plaintiff because my thought was that there may be a third party complaint somewhere. But anyway, that's who I'm talking about. That person didn't show up.
She's not a plaintiff anywhere.
All right.
That's number one. This is a direct
Well,
cause of action.
Yeah, she's a principal person here, given the fact that that she's the person upon which service have been provided and benefits are sought. Go ahead, Mr. Stone.
It's a direct cause of action pursuant to the no fault statute. And number two, this is against MAIPF, and they have not assigned the case yet to a carrier, and which under the directive of the governor and the insurance commission, they have 30 days to do so. So the deposition that is requested by Ms. Mahone shouldn't even take place by her unless she's representing an insurance company.
Wow. Ms. Mahone.
Yes, Your Honor. So I guess to start, Miss Sakia Harvey did appear for a deposition. She appeared and got angry and signed off the Zoom deposition while I was attempting to take background information. I was asking about where she lived, things that are relevant to possible resident relative information. She indicated that she had lived different places. So I was gathering information to determine if there's a possible, other insurance company in higher order priority through a resident relative. She refused to give information. She got angry. She signed off the Zoom link. We waited for several minutes for her to sign back on. She never did. So that's the reason for our motion to show cause, to continue to obtain that information. And I do believe the MAIPF does have a right to depose an individual to try to obtain that information to make that initial determination of eligibility.
All right, and so is that deposition a predicate to the placement facility's ability to assign the claim?
In this case, yes, because there's missing information that is needed in order to make a determination as to eligibility.
All right, thank you. All right, so I mean, let's get to it then. I mean, I don't think that this. Well, ultimately, I guess this could have some effect on the claim that is brought by the plaintiff herein. But I don't like this clogging up the wheel here. If you want the deposition and you want the court to issue a show cause in this matter, if there's a person that's subject to process here, then they should be participating in the deposition. So I will sign an order for show cause regarding that individual for their failure to appear at the deposition. And so if you'll submit an order in that regard, I'll get that set up, even if the deposition have to take place with the court's supervision at the same. And Mr. Stone raised the issue about the claim not being assigned. The argument that connected to that somehow in a matter that is now present before the court, that a claimant, an underlying claimant, would not have to respond to a deposition. I don't know where you get that argument from, Mr. Stone.
No, that's not what, they're a non-party. It's not a basis to throw our case out or anything like that.
I never said anything like that, and I don't think that anybody suggested that, not at this point. But you gave the suggestion that somehow, because this claim had not been assigned to a particular insurance company, that person does not have to participate in the issuance of a subpoena to participate in a deposition. I'm troubled by that kind of analysis.
Yeah, no, Your Honor, just because it wasn't assigned. So what's going to happen here is they have 30 days. Pardon?
Yeah, hold on a second.
Yeah.
My headphones went out. Hold on one second. All right. Oh, what happened there? All right. Are you able to hear me okay?
Yes.
Okay, I can hear you now. Go ahead, Mr. Stone.
So they have 30 days to assign the case. That came down from the state of Michigan. There's no ifs, ands, or buts about that. So what's going to happen here is, now once she takes the dep or not take the dep, the case is still going on. I can't bring a cause of action. There's got to be an insurance company instead of MAIPF.
All right. Yeah. So yeah, you put the cart before the horse. Hold on one second. Oh no. Okay, gotcha. All right. Sorry about that. All right. Yeah, I think you put the cart before the horse. I mean, that's not the issue that's been raised at this point. What I think Ms. Mahone is trying to do is get this deposition out of the way. And I think that benefits all the parties involved, because I guess where the plaintiff wants to be in this is that the claim is in fact assigned, and whatever the issues are with the claim can be directly addressed. And this seems to be a clog in that in the wheel on that.
Yeah, so what's going to happen, Your Honor, is it's going to get assigned, and Miss Mahone's not going to be the attorney of record unless she represents that insurance company. It could be assigned to Allstate, then we're going to have all new counsel, and they're going to want to take the dep over again.
Well, they're going to already have a dep that's been taken, and if in their wise counsel they believe that they need more information, then well, you know how the rules work with that.
Yeah, they're going to get a second bite at the apple and take a dep.
More than likely they will, but that doesn't prevent the first bite, is what I'm saying. All right, so let's get this done. Ms. Mahone, what's your most efficient way that you can go about doing that? Mr. Stone, do you have any control over this particular individual to get them into that deposition, sir?
No, Your Honor.
All right. So I'll issue an order to show cause, Madam Counsel. Just get something drawn up and sent to me. The court will sign such an order. You can send that to that email address I gave earlier. Do I need to give it to you again?
Yes, I'm sorry, I missed it.
No, that's not a problem. It's Latifah, LATIFAH .Hunter @36districtcourt.org.
Okay.
All right. Anything else? Oh, sorry. Go ahead, Ms. Mahone.
And I think before you were saying that the court will issue a date for that.
Right.
After I give you the order.
Yeah, you get the order. Get the order in, and I will give you. I will put in the order a show cause date for the hearing on the show cause. Regarding any other pretrial matters at this time.
No, Your Honor.
I just want to have a date for discovery cutoff, because I know right now we are saying discovery through today. Can we just have a date for when discovery would be cut off then?
Yeah, got you. That's through today. So what you're asking for, you already know that it's cut off today. Is what you're asking is the court would extend it for a period of time. I suspect what you're asking. You already would have the right regarding this deposition, because you made that request before discovery was cut off. Are you anticipating any other issues of discovery at this time? You don't have to put your hand up, Mr. Stone. I'll come back to you. Go ahead, Madam Counsel.
No, Your Honor, at this time, I don't see any other issues, but I guess I just wanted to make sure with having the deposition of the claimant in this matter, if we needed to request additional information from her, that we were going to be able to do so.
Gotcha. All right. Mr. Stone?
Yeah, see, Your Honor, with extending discovery, I can't even take the dep of an adjuster yet. There's no adjuster on the case. No one's been assigned. So that's the problem with not assigning the case. Who can I take the dep of the adjuster? There is no one.
Yeah.
So discovery has to remain open until she assigns the case. And I'm going to file a motion to have it assigned.
All right, I'll address any motion that you might file, and certainly when this case, if and when this case is assigned to someone, I'll take up those issues at that time. Obviously, you will not be prejudiced by any need for discovery that may arise out of the case being assigned a particular way. We'll address that at that time. As the case stands now, I will extend discovery under these special circumstances for a period of 45 days. So that is going to put, and I'm really setting that out to give a date of hearing for the parties to come back. So discovery be extended until the next hearing date. And that next hearing date is going to be March 17, 3/17/2022. And that's going to be at 9:45 a.m. If you have a motion that you wish the court to hear, you can file that motion and set it for hearing on the 17th at 9:45 a.m. so long as you allow at least 7 days notice to the opposing party. So if you're filing a motion, notwithstanding what the rules may be otherwise, the court is issuing an order. You'll get an order from me that allows you to file motions and set them for hearing on the 17th of March, 2022 at 9:45 a.m. so long as you provide at least 7 days notice to the opposing party prior to the hearing. All right. And we'll address whatever other issues you may have at that time. All right. Good day to the two of you.
Take care, Your Honor. Thank you. My pleasure.
And Ms. Mahone, get that to me, and we'll set it on. I'll try to get that show cause set before that date. So get me a show cause out so I can get it right away and get that all set up, okay?
Absolutely. Thank you, Your Honor.
All right, thank you. Good day to you.
You too.
Just one moment, everyone. All right, this is case number 21-150003. This is comprehensive care pain management versus Detroit Department of Transportation. The matter is before the court, set on for a pretrial, set on for a hearing regarding this matter. Your appearance for the plaintiff at this time, please.
Thank you. Good morning, Your Honor. Rennie Calvin, P74631 on behalf of the plaintiff.
All right, thank you, and good morning to you as well.
Yeah.
For the defendant, counsel.
Good morning, Your Honor. Gregory Patterson, P75963 here on behalf of the defendant. And as a point of clarification for the record, Your Honor, by stipulation, the City of Detroit Department of Transportation has been dismissed. City of Detroit is the only remaining defendant.
Thank you, counsel. And I remembered something like that, and then so I'm looking and saying, why is my notice still going out with that with that there? So we're gonna make sure that we get that corrected in our records. I already have it corrected in the file, but we'll make sure for the notices purposes. All right. So I think that there was some issues of initial disclosure. So where is the case now in terms of discovery and what's needed to move this matter forward?
Well, and Your Honor, this case has kind of bounced around. It's been transferred. We did send some discovery requests several months ago. Plaintiff's counsel, to his credit, did reach out to me. We didn't have a chance to go to a breakout room, but long and short is that we have outstanding discovery and would request an order, ordering the response to be produced. I have no problem if plaintiff's counsel needs some additional time on that. Not seeking sanction at this point, just an order to protect our interests.
All right, counsel.
Yeah, we just subbed into this case, took over for previous counsel. We did reach out. I was reviewing it. It looks like we have started the discovery. We have some answers. So I anticipate we'll have a full answers there, and I'll get initial disclosures moving as quickly as I can. Because we just subbed in and took over this case. So, I mean, I got a lot of catch up to do. So,
and to reiterate that point, Your Honor, if they need 21 days, 20 days, I'm fine with that. Just would like to have an order there to protect this, moving forward. That's all.
All right. All right. Well, that certainly makes sense. I do have a breakout room if you guys want to talk. My indication here would be to set this over for 30 days, just to bring it back because it's been going on for a little while. And within that 30 days, the answers are to be turned over. And then I have the parties back to see where things are at that time. Does that seem too soon to you, Mr. Patterson? Go ahead, sir.
Yeah, Your Honor, 30 days, I would have no problem with that. I understand that plaintiff's counsel has just subbed in, giving them the full discovery period to respond. I have no problem with that.
All right. So, Mr. Calvin, I'm going to go ahead and do that, and I'm going to bring it back on a short tail. So we're going to go ahead and set it over for an adjourned pretrial date. And I'm going to set that date for the 7th of March, 3/7/21. 22. We don't want to go to 21.
we did it once. We don't want to do it again.
We did it once. We don't want to do that again. 3/7/22, and we're going to go ahead and set that for 9:45 a.m.
And Your Honor, if I understand the court correctly, their initial disclosures and discovery responses will be due on or before that date?
On or before that date, yes.
Your Honor, would you like me to prepare an order to that effect, or will the court issue one?
You can. I'll go ahead and issue an order on this.
Very well, Your Honor. Thank you very much.
All right. We'll
Thank you,
get
Your
it
Honor.
done. All right.
Good meeting you, Mr. Calvin.
There you go, Greg.
Good day to you. One moment, everyone. Almost there. All right, the court now calls case number 21-16000-8. This is Tox Testing Lab Incorporated versus City of Detroit. The matter is before the court, set on for a pretrial conference. The pretrial in this matter was previously adjourned to, and the court extended, I believe, discovery through today's date. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. This is Robin Brooks on behalf of the defendant, City of Detroit, P47787.
Thank you, Ms. Brooks.
My counsel, opposing counsel, he is not present today because he had another court matter. This matter is settled. We settled the matter, and so we'll probably need some time because, of course, it's contingent upon City Council approval.
All right. Thank you, Ms. Brooks, for that information. What I'm going to do, Ms. Brooks, you may have gotten one from me before. I'm going to send out an order contingently dismissing the case that can become a permanent dismissal. In that order, it says that the parties have reached a resolution that is pending pending resolution approval by a governmental body. And to the extent that that is done, the case would be permanently resolved. If for some reason that process falls through, the case would be automatically reinstated. That's typically the way that I do that. So that's what my intent is, to send out such an order.
Okay, that's fine, Your Honor. Normally we dismiss it with prejudice. I'm assuming your order is being submitted without prejudice.
Well, the order itself says that it is without prejudice until the City Council approves it and funds are dispersed. Upon dispersal of funds, the dismissal is with prejudice.
Okay, that'll be fine. I just want to make sure. Just needed to make sure.
Yeah, it's got the automatic reinstatement, but it also has the the permanent dismissal. If those funds are dispersed, it's dismissed with prejudice.
Yes, sir. That's what I appreciate about you.
All right. Thank you. So good to see you. And
You
we'll get that
too.
order.
Have a great day now.
All right. Likewise. All right. The court now calls case number 21-166-458. This is Biomolecular Integrations Incorporated versus Auto Owners Insurance. The matter is before the court on the filing of a motion for summary disposition. Your appearance for the plaintiff in this matter. All right, do I have a Biomolecular on this Zoom? Do I have Auto Owners on this Zoom? All right, we'll come back and try and call that at the end to see exactly what may have happened there. All right, the court now calls case number 20-162399. This is Laboratory Specialists of Michigan versus City of Detroit. The matter is before the court, set on for a pretrial hearing. This is, well, looks like it's set on for a motion hearing. All right, your appearance for the plaintiff regarding this matter.
Good morning, Your Honor. Amal Muzim on behalf of plaintiff P84247.
All right, thank you, counsel, and good morning to you.
Good morning.
All right, for the City of Detroit, your appearance at this time.
Good morning, Your Honor. Yvonne Bradley appearing on behalf of the City of Detroit, P54885.
All right,
Your
thank
Honor,
you. Thank you, Miss Bradley, and good morning to you as well. Right.
Good morning, Your Honor, if I may. I'm not here on this particular matter. However, I would like to try and locate the attorney assigned to the case. Can you identify that individual for me, sir?
Yes,
It's
I
Phil
believe it's,
Hiltner.
Phil Hiltner? If Your
Yes.
Honor will give me an opportunity to reach out to him?
yes.
Okay.
Just let me know when you're ready on that. And thank you, Madam Plaintiff Counsel. We'll come back to your matter.
Thank you.
In short order.
Thank you.
Mhm.
Thank you, Judge.
Thank you. All right, the court now calls the just one moment. All right, let me have Anderson Medical Supplies versus City of Detroit. That is case number 21-144-120. That case is set on for review on today. So it looked like there was the matter was mediated. And all right, your appearance on this matter for the plaintiff.
Good morning, Your Honor. Yusuf Faraj on behalf of plaintiff P79760.
All right, thank you, Mr. Faraj. And do I have plaintiff for the defendant? That may be Miss Bradley or.
That's me, Your Honor. Charlotte Bennett here on behalf.
Oh, okay, Miss. Go ahead into your appearance this minute. I didn't want to trap Miss Bradley there. Go ahead and enter your appearance, if you will, Madam Counsel.
Yes, Your Honor. Good morning. Charlotte Bennett, P85699 here on behalf of City of Detroit. We're actually substituted counsel for Mr. Greg Pattison, who I believe is counsel of record at this time.
All right, very well, very well. So this came to me, and it seems like on at the last hearing that the mediation had occurred, and that the parties were talking to see if they could come together on this. If my memory reflects me right, somebody update me.
That's correct, Your Honor. Case evaluation award, defendant accepted, plaintiff rejected. Unfortunately, the award was just too low to try and get my client to accept. We did extend a demand. I believe the offer, I believe defendant is stuck at case evaluation. I'm still trying to work on my client. If there is room for negotiation and settlement, I hope it could still happen. At this point, I believe we were set to come back to see if the case could either resolve or if Your Honor would give us a trial date. And of course, in the meantime, we would still try and settle.
All right, makes sense to me. That's
Your Honor.
Ms. Bennett.
So we actually just substituted in. We don't have the true copy of the substitution order yet. So at this time, I don't have settlement authority to work with plaintiff's counsel. So if we could get a 60-day adjournment to just get up to speed on the case and try to resolve this, I think there's an opportunity for resolution. I just need to, we just need to get in the case and get up to speed.
That makes sense to you, counsel?
Yes, that's fine with me, Your Honor.
All right. I kind of like 45 days better. I like to see you sooner rather than later, but and that's only because it's been kind of going on a little bit, but it doesn't make a whole lot of difference. Let's get a date here together, and I'll adjourn it over for pretrial, and we're going to go ahead and we'll go ahead and set that date for the 22nd of March. That's 3/22. 32222. And that's going to be at 9:30 a.m. I'm treating it as an adjourned pretrial. And so we'll take a look at where the parties are at that time. Obviously, there's been some attempts to try and get it resolved. Let's see where it is, and perhaps if it hasn't been resolved, I can weigh in a little bit and see where things are to see if we can get this to the finish line. And then the other thing is, of course, setting it over for trial if that's a necessary next step. Okay. So 3/22/22 at 9:30 a.m. is the next hearing date in this matter.
Understood. Thank you, Your Honor.
Thank you. Good day to the two of you.
Same to you.
You as well.
One moment. Okay. All right. Case number 21-153-513. This is Citizens Insurance Company of America versus Alea Dewan Baytops. The matter is before the court, set for a motion hearing on today's date. Your appearance for the plaintiff regarding this matter.
Good morning, Your Honor. Jennifer Risen, P55496 on behalf of Citizens.
All right, thank you, and good morning to you, counsel. Deja Baytops, Alea, I'm sorry, Baytops, if you're on the Zoom, please say something at this time. All right, I'm looking for Baytop, who lives at an address in Detroit on Glenfield. If there's any person by that name or any person representing that individual, please say something at this time. The record should reflect that the plaintiff has brought a motion for entry of default judgment. The default of the defendant has already been entered. The plaintiff is requesting that the court would enter judgment. This is a case where Citizens was assigned this claim arising out of the ownership and operation of an uninsured motor vehicle, and paid out certain items under the claim and processed the claim, and is now requesting that judgment would enter for the amounts accrued as it relates to PIP benefits and loss adjustment costs and expenses. Counsel, looks like you're asking that judgment would enter by default for the sum of $14,849.34. Is that correct?
That's correct, Your Honor.
All right, anything else you want to bring to my attention at this time, please?
No, Your Honor, I guess I'd just like to make a record that the defendant was served November 1st regarding this motion. We have not heard from defendant at any time since filing of this suit back in April of 2021.
All right, and I've looked through the file to see if there was anything sent to the court. I see nothing that's been provided in any sense as a defense or as notification that defendant wishes to proceed in any way in this matter. Accordingly, and given that there has been a proper motion and proper service of the same, the court will enter now the judgment by default, and that judgment will enter for the sum of $14,849.34. I'm signing the order accordingly. Thank you, counsel. We'll get a copy of that out to you.
Thank you, Your Honor. Have a great day.
And likewise. One moment. All right. All right, this is case number 21161765. This is Charles Pembroke doing business as PSG Protection Services LLC versus Alfred A. Coleman doing business as All Inclusive Security and Investment. The matter is before the court after the filing of a claim by Pembroke, and on the filing of a motion, looks like in lieu of answer, a motion for summary disposition in this matter. Your appearance for Pembroke, or if Mr. Pembroke is here, whoever is here regarding this matter, please state your name at this time. All right,
Your Honor, Herb Sanders on behalf of.
One second, Mr. Sanders, just one moment.
Okay.
I'm looking for Mr. Charles Pembroke or any person regarding the PSG Protection Services LLC. The record should reflect that a notice of the hearing on the motion for summary disposition did go to an address on Naviva Court in West Bloomfield, Michigan. The record should further reflect that that address is consistent with the filing of the complaint in this matter. That complaint was filed on the 22nd of July of 2021. The address provided there was the exact same address that the court sent its notice to. On the notice sent to the court, it provided for a virtual hearing scheduled for this particular Zoom on this particular date, and it provided the Zoom number. That notice went out on December the 9th of 2021. One more time, I'm looking for Charles Pembroke or any person associated with PSG Protection Services LLC. The hearing was set for 9:45 a.m. All right, your appearance for Alfred Coleman, an all-inclusive security and investment, sir. You may at this time.
Good morning, Your Honor. Herb Sanders on behalf of the defendants in this matter, Mr. Coleman and All Inclusive Security and Investments.
All right, thank you, Mr. Sanders. I think did you give your P number, sir?
P43031.
All right, thank you, sir. Mr. Sanders, Counselor, it looks like the plaintiff who brought this lawsuit has not appeared regarding this matter. I know that you brought a motion for summary disposition in lieu of answer to the complaint. I've read the motion. I know that there was not a response to the motion. In reading the motion, I anticipated that the other side would be here and raise some factual disputes that would defeat the motion for summary disposition, at least at this point, because it seemed to be maybe, I was suspecting that it might be a little bit premature, given that there seem to be some embedded factual kind of disputes. But I don't know that to be the case. I was hoping to see the other side here. They're not here. It's their action, and we've notified them, and they've simply not appeared for this hearing. So my inclination at this point would be to grant an order dismissing this case at this time, and for their failure to appear, I would hold in abeyance the motion for summary disposition if there is a motion to reinstate and there is some reason that would allow for reinstatement. I suspect that if there is a motion to reinstate, that a part of the arguments raised in the motion for summary disposition would also be issues that you would raise as to why the case should not be reinstated. So what I'm going to do at this point is I'm going to enter an order dismissing this case where the plaintiff has failed to appear on this date that has been duly noticed. And in fact, He's had a month and a half notice on this. And Mr. Sanders, you received the notice. Is that correct, sir?
I did receive the notice of hearing, Your Honor. Additionally, we sent our motion for summary disposition to the address that the court has reflected that the defendant provided to the court, or the plaintiff provided to the court, and we received no response to that motion either. So we understand the basis as to why Your Honor is proceeding in the fashion that you have indicated you will today, and we appreciate your consideration.
Thank you, counsel. So I am signing an order that will, in fact, dismiss the case, and you'll receive a copy of the court's order. We'll try and get that out in the mail today, sir. All right.
Thank you, Your Honor. Have a great day.
Thank you, Mr. Sanders. Good to see you, sir. Good day to you.
You too.
All right, this is case number 21-147838. This is Preferred Rehab Care versus City of Detroit. The matter is before the court after entry of an order granting a motion for partial summary disposition. That motion was previously granted in part, denied in part. All right, your appearance for the plaintiff in this matter, Preferred Rehab.
Good morning, Sharif Arif, appearing on behalf of plaintiff P74522.
All right, thank you, Mr. Arif. And for the City of Detroit, if you will.
Francis Dane, Embry Barnes, appearing on behalf of defendant City of Detroit, P1574. I'm sorry, P61574, Your Honor. I'm so sorry.
How you get that? How you get that one mixed up?
I know. I'm falling asleep here.
All right, not a problem. We work too hard for those ones. That number got to get embedded in your spirit. All right. So what's going on here? I know that I think Ms. Mills was here before or something on this one.
Yes, Your Honor, but we're here for a final settlement conference, and Your Honor, the parties have come to a tentative agreement with regards to a settlement. However, there's an outstanding issue regarding a previous payment that needs to be investigated and followed up on, which would affect the overall amount of the settlement. So the parties have agreed to request the court adjourn this out for 21 days to give us a chance to resolve that outstanding issue about the previous payment. So when we come back to the court, we can put a true number on the record as to the final settlement agreement.
That is, yes, that's an accurate representation of what's going on right now. So I anticipate we'll have this resolved once we get to the bottom of the alleged outstanding payment.
All right. I like the language. It says, defense counsel says there is a previous payment, and the plaintiff counsel says an alleged previous payment. All right. Sounds like lawyers to me. All right. So I will adjourn the matter over. We'll take a review of those items in February. So let's look at February 28th, 2/28.
Okay.
Well, I guess we don't have to go that far. You want to come back sooner than that? I can put it that week before.
That would be great. I have a trial that day.
All right, let's do it the 21st. That should be enough time.
Yeah.
2/21, 22, and I'm going to go ahead and set that for 9:30.
9:30?
Yes, ma'am.
Thank you, Your Honor.
All right.
Have a good day.
I'm setting it for review, so we'll get things worked out at that time.
All
Thank
right.
you.
Good day to you.
Okay.
All the best. Thank you for your patience.
Thank
Bye-bye.
you.
And Miss Bradley, on the, I don't know if we addressed your matter already, or I know you were here for somebody, so we got you weaved in here some kind of way. So
That's okay,
I'm looking
Jeff.
at 2016-2399. That's of course laboratory specialist versus City of Detroit. Madam Counsel, Ms. Amal, say that last name for me again.
Museum.
Madiam?
Museum.
Museum.
Yes.
All right, Miss Museum.
Thank
I got you now, man. Thank you. Love that first name.
Thank you.
Miss Bradley, you were trying to find somebody.
Yes, Your Honor. I did not have Mr. Hartner's direct number, but I did reach out to someone, and unfortunately, I don't have any information regarding his whereabouts right now. Perhaps if Your Honor would like to put us in a breakout room, maybe I could assist in the matter. I don't know what the motion is about.
Yeah, I mean,
I'm willing.
it's nothing huge, so we can talk about it.
Okay.
Yeah, that sounds like a good thing to do, and it gives me a chance to use a break room today, and so that's always a good thing. So I'm gonna send you guys to breakout room number 1, and I'll be here when you return.
Thank you, Judge.
All right, thank you. Matter reporter, you good there?
Yep. How you today, Judge?
I'm good.
How you like working from home?
Oh, it's all well. It's all well. Officer Talbot, you there? You there somewhere?
Yes,
sir. How you doing?
Oh,
I'm good. All is well there?
Yes, sir. All is well.
Perfect. All right. Have we seen a Latifah sighting yet or no?
Latifah is not here.
yeah, she said she's not here today.
Okay. I thought she was gonna be a little bit later.
Oh,
that's okay.
Clerk. We do have a clerk though. She just stepped out and went to the bathroom.
Brandy.
Gotcha. Not a problem. Perfect. All right.
Oh.
We'll get some stuff done.
Mm-hmm. Let me put this on hold. Whew. My hair is a mess.
George from dealer processing calling because the factory warranty on your vehicle is set to lapse. So one needs to be responsible for paying expected repair bills that come up. So you can call back at 833-002307 so we can reinstate your coverage.
How are you, sir?
I am good. How are you this morning?
I am doing well.
I apologize.
Not a problem. Not a problem. I think you're here on the Lab versus City of Detroit, right?
That's right.
Yeah, Miss Bradley was talking to Miss Amal, and
Yes,
still messing up on the
that's
last
fine.
name. And they're coming out of the breakout room now.
Oh, I'm here. I think Miss Bradley ended up leaving.
Ah, okay. So Miss Bradley stood in for you and had a conversation with Madam Council, and Mr. Hilner has just appeared in on this. So go ahead and enter your appearance at this time for the city, sir.
Okay. Good morning, Your Honor. Philip Hiltner, P77913 for defendant.
All right, and that case involves a suffix 399, Laboratory Specialist of Michigan versus City of Detroit. So let's start, Madam Council. Let me know what happened in the breakout room. I'm sure Mr. Hilner wants to know too.
Miss Bradley was just trying to get a hold of Mr. Hilton there. She called someone that knew someone, and so we got him now. Nothing other than waiting.
All right, not a problem. Not a problem. So, Mr. Hilner, tell me what's going on here. It looks like I sent an order granting a motion for summary disposition, and it said the complaint is dismissed. That was back October 21, October 4. But now I got a motion hearing set for today's date. So somebody update me on what's going on? I should know, huh?
Yes, Your Honor, this is my motion. Your Honor, the date of the motion, we never received the motion from Mr. Hiltner or the office, or we never even received an order from the court. So we had no idea to appear on it. So we didn't file an answer. We didn't appear. And because of that, the case was dismissed. So we filed this motion for relief so that we can at least get an opportunity to look at the motion, file a response, and so we're here. we got notice of this in October 25th when the order granting the MSD was mailed to the office. And then we looked at the ROA and we realized the last order we ever received from the court was on June 1st, 2021. And it was for a conference. I think it was a status conference.
All right. Yeah. All right. Yeah. So I see now your motion for relief from judgment pursuant to MCR 2.612. Mr. Hilner?
I certainly don't doubt what plaintiff's counsel is saying here today. My only response is I don't believe I ever received plaintiff's motion to set aside the judgment as a notice of today's hearing. So yeah, I'm not sure what happened in this case. If they didn't have notice of the prior motion, then I guess I can't really object. I would just ask for a new hearing date on the underlying motion, and we go from there.
All right. So what is it? All is fair in war and court. I know it's war and love, war and court. So you file a motion, they don't get it. They file a motion, you don't get it. I guess we're even now. Right.
Well, I thought we mailed it to you guys, so I thought you had it, and we have noticeable. You know what? I believe you too. So just like you believe me, but yeah, I think it'd be fair that we can both at least get a chance to fight this out with another motion.
All right. So what I'll do is I'll set aside the order granting the motion for summary disposition at this time, and I'll go ahead and set it up for set that motion up for a hearing date. And have you received a copy of the city's motion, Madam Council, at this point?
No, Your Honor, I still don't have it. Philip, if you can just email that to me directly.
Yeah, no problem.
Okay. All right. So I'll go ahead and set it up. I'll go ahead and set it up for a hearing in the month of February. Let's try to get you back here. Let's see. I'm working remotely today, so let's get you a date here. So I'm thinking February either the 23rd or the 28th.
Either or works for me. The later is probably more preferable for me, the 28th.
I'm sorry, wait, I missed the month. Was that March or February?
February, sir.
23rd.
Council's kind of saying in a
Either
roundabout
one.
way that she wants the 28th.
28th is great for me.
All right, so I'll set it on the 28th of February, 10 o'clock a.m. for motion hearing.
Thank you so much, Your Honor.
All right, thank you. Good day to the two of you.
You too. Thanks.
Yep, thank you. Take care.
All right. Again, Biomolecular Integrations Incorporated versus Auto Owners Insurance Company. That is 21-166458. The matter is set on for defendant's motion for summary disposition. Neither party has appeared on this matter. I'm going to go ahead and reset it, and I'll set a new date. So I'll reset the matter. In fact, let's go ahead and reset it for 2/28/22, 10:15. All right.
All
Well,
right,
Ms.
all right.
Deborah?
Yes, sir.
All right.